Muchas gracias y bienvenida a todos. Vamos a seguir este muy interesante congreso y vamos a seguir esta tarde a principio con el papel de los jueces. Pero antes de dar la palabra a mis colegas, quiero agradecer a los organizadores, claro, sobre todo a Chema, José María, que es un organizador magnífico, y también a sus ayudas, que pienso en Yolanda y también a Tania, que nos ha ayudado muchísimo para que el Congreso sea un suceso. Vamos a hablar del papel de los jueces en Francia, España y el Reino-Unido. Y este papel es muy importante, creo, para establecer el estatuto de los trabajadores de las plataformas. Los jueces de las Cortes Supremas han hecho un trabajo claramente muy interesante, así que verlo de un punto de vista comparable es muy interesante y tenemos mucha suerte de tener unos especialistas de cada país. Así que inmediatamente doy la palabra a Sylvain Lolon, que es abogado general en la Cour de Casación en Francia y que conoce bien esta jurisprudencia. Sylvain.
Thank you very much, Cécile, and thank you very much for the organizer of this conference, and it's really a pleasure to be here and to be in this panel. Of course. So, I start again. Sorry. Hello, everybody, and thanks a lot to everybody and to the organizer. And it's a pleasure to be here, especially in Santiago. And I think we are the only, maybe, panel in live. So totally atypical, but very interesting. Anyway, so I will now start to speak about the role of the French judges, the French Cour de Cassation, but also the French Constitutional Court. So before to start trying to answer the question, I will make two initial comments. And these two initial comments are totally obvious, but I think it's nevertheless important to say a few words about it. The first one is that we are speaking about the role of the judges. We never have to forget that a court will only play a role if a case has come before the judges, and the judge only intervenes within the framework of disputes, and he will only answer to the question he is asked to answer. And I think we shall never forget this, because you cannot expect the judges to give a general answer, or sometimes you are expecting, or we are seeing things in the decision that they are not, because it wasn't asked, or it was not in the procedural. It was not in the procedure. So the second thing the second introductory remark is about the legal context, because of course the role of the judge will also depend on the legal context. So I will start, before presenting the French decisions, to speak about this legal context, and I will say a few words about what I call the pre-Uber context, and after the context with the digitalization of labor law. So in France, we do not have a third category of worker. We just have a binary distinction between independent contractors and employees. This presentation must be tempered because it's true that we have also, in a specific and old section of the labor code, specific rules about specific professions. Journalists, for example, models, also home workers, some managers of business, and so on. And in this specific section of labor code, we've got some protections afforded to these workers by the legislator. So also, when we are speaking about this legal context, we do not have a legal definition of the employment contract, which is, I think, very common among the countries, but we've got a quite a recent definition of self-employed, and the idea is that self-employed is presumed to be one whose working conditions are defined exclusively by themselves or by means of the contract with a client. So, as I say, no legal definition, so we've got a traditional definition of the employment contract given by the court, and we've got a famous case from 1996, the case Société Générale, which gave a definition of the contract of employment, and it states that the relationship of legal subordination is characterized by the performance of a job under the authority of an employer who has a power to give orders and instructions, to oversee performance, and to sanction the subordinate for any breaches. So we see in this definition that what is a key element is, of course, the subordination, and the subordination is linked to three powers, I will say, to direct, to control, and to sanction. So it was, let's say, the pre-Uber context. And of course, before we have this case of the Cour de Cassation, there were, of course, a lot of debates about what was happening with the digitalization of the society. And we had, let's say, intense debates about could these workers be qualified as subordinated workers? Do we need a third categories? Even if before we already had these debates, but let's say that it was much more intense with the introduction, with the Uber, let's say, drivers starting to drive in France, in Paris, and so on. And we also have a lot of official reports about this digitalization and the nature of relationship between the platforms and the workers. And another element in this context is that the legislator has started to regulate, and the first legislation was enacted in August 2016. It's a very limited legislation, but let's say that the legislator is mostly, let's say, want to consider platform workers as independent workers. So the legislation just applied to independent platform workers. It gave these workers some rights, but mostly these rights depends on the platform. So it's sort of a voluntary protection. And also it just applies to certain form of platform. Let's say the mobility platforms. So mostly to drivers and also all the food deliveries or this type of platforms. And last element about this legal context, the lower courts were divided on the issue of reclassification, and the majority of the lower courts were, of course, they were asked by workers to reclassify their work relationship in employment contracts, and the majority of lower courts decided not to recognize the existence of an employment relationship for platform workers. So it was a legal context before the first decision of the Cour de Cassation. And now we'll speak about three decisions of our Supreme Court, the French Supreme Court. The first one is the first decision about platform workers. It's a 𝐂𝐻𝐻𝐸 case. I will after speak about a very important decision of the Constitutional Court, and finally, the last, for the moment, decision of the Cour de Cassation, the, let's say, Uber decision. So the first cases was about the company 𝐂𝐻𝐻𝐸, the platform 𝐂𝐻𝐻𝐸, and let's say that very classically, it involved a company that used a digital platform and an app to connect partner restaurants, customers ordering food through the platform, and delivery riders. The company has been wound up, and one of the riders go to court to ask the court to reclassify his contract in a contract of employment, of course, to benefit from at least the dismissal benefit, and also to some wages and so on. So in this decision, the Paris Labor Court dismissed his claim, but the Cour de Cassation ruled otherwise. And the Cour de Cassation first recalled a basic principle of this case law, that the existence of an employment relationship does neither depend on the will expressed by the party nor on the designation that the parties have given to their agreements. It depends on the factual circumstances in which the workers exercise their activity. Therefore, the qualification given by the parties to their agreement is irrelevant. The judges have to look at the factual circumstances of the work. And the Cour de Cassation then recalled the relationship of subordination and recalled the definition I presented just before. So a work relationship is characterized by the powers of direction, control, in sanction. And in the 𝐂𝐻𝐻𝐸 cases, what were the elements important for the court? It was geo-tracking of the workers. It's not the use of the geo-tracking system which was important, but the fact that this system was used to control the activity of the riders. And another very important element was that there were some sanctions when the riders decide not to connect or decide to disconnect to the app. So the Cour de Cassation concluded in 𝐂𝐻𝐻𝐸 that it was a contract of employment. The second decision is also quite important. It's the decision of the Constitutional Court. And why the Constitutional Court? Because at the end of 2019, the legislature decided to adopt an act on mobilities. And in the law, in the LOM Act, there was a provision stating that platforms could adopt a social responsibility charter, so it was totally voluntary, to provide some protections. But what was very important is that the charters cannot be used to justify the reclassification of contracts for the provision of services as employment contracts, which means that if the platform adopts a charter, it couldn't be used to reclassify the contract. So we see here that the legislator wants these workers to be independent, so creating a very strong presumption of independence. And the Constitutional Court partially invalidated this provision. It is up to the judge to reclassify the relationship between the worker and the platform. So it means that the legislator, cannot really, it can decide that it's an independent contract, but at the end, if there is a legal subordination, it is for the judges to reclassify the relationship. So, of course, it was an important decision. And now we arrive to the most important maybe decision in this context is the Uber ruling, so 4th March 2020. Of course, it's, let's say, normal Uber relationship. But compared with the Take It Easy cases, what is important is that the Uber drivers have much more freedom than the riders in the Take It Easy case. Because you do not have any control of when they decide to connect or disconnect. So we were not sure. It was difficult to know what would be the decision of the Cour de Cassation. But in this case, the Court of Appeal decided that it was a contract of employment. So in the Uber ruling, the Cour de Cassation started by recalling the traditional definition of a contract of employment and decided that it was a contract of employment. What was important, because I see that the time is running, so let's say that what was important in this decision is that let's say that for the court, what was important, it was really the idea that the worker was part of an organization, a work organization, and this organization was defined by the platform. So it was included in this organization. Also very important is that you had some sanctions. So it was possible for the platform to briefly disconnect the taxi driver, the Uber drivers, which means that you could characterize the employment relationship. Just because... so some comments about these two decisions, the Take It Easy and the Uber decision. First, the Cour de Cassation decided to give really the widest possible publicity to the two decisions, and especially to the Uber decision. The decision was immediately published on the website with an explanatory note, a press release, and a translation of the decision in English and Spanish. It was the first time that the Cour de Cassation in labor law for the social chamber decided to immediately translate this decision. And I think it shows that the Cour de Cassation, I will say, is totally aware about the debates all around the world and want, I think, to participate to these debates. And the fact is that the decision goes with an explanatory comment and a press release also shows that the court wants its decision to be explained also to non-French lawyers, also to people who are not lawyers, to really explain the decision. If you look now at the legal reasoning, what is also quite, I will say, paradoxal is that the courts and the commentators really present these decisions as a totally classical decision, a totally conventional and classical application of the old notion of contract of employment. And it's really clear from the comment. So I say that it's interesting because everybody was wondering, is it really a contract of employment or not? And the court just said, but yes, of course. And we do not need to adapt our definition. Our old definition is perfectly working, and we can use it to reclassify the relationship. And I think that I thought about it when I was preparing the presentation. It's a bit, I think, like in the 𝐲𝐿 decision. In fact, at the beginning, I was quite shocked with the 𝐲𝐿 decision because I said, well, all Europe, all the world is wondering, is there a contract of employment? And the European Court said, oh, it's not a problem. And we already answered to this question. And I think the Cour de Cassation maybe is doing also a bit the same. Also, what is very clear from the decision and from the comments made by the judges themselves, so not for outsider, let's say, of the decision, is the importance of European law because it's used as an explanation for not, let's say, change the definition and for not using other criteria like economic dependence and so on. So let's say that they say we have this European definition, and this European definition is the same than the national definition. So if we change the definition, it's not going to work because when we will have to apply to legislation on working time and health and safety, we will need to use the European definition and for the pieces of labor laws, the new definition. So it's not possible. So we need to keep this definition because it's also because it's the same than the European one. Also, another important thing is that the court in the press release refer to the constitutional decision also because say that in the decision of the Constitutional Court refers to the legal subordination, so we cannot escape this subordination. And also the importance, not in the decision, you cannot see it in the decision, but in the preparatory documents of comparative law. The French judges, before to rule, analyzed what was happening in not all the countries, but quite a lot of countries. So it's very important in this debate, this international, let's say, it's an international debate, really. And I have to conclude because just as a conclusion, I will say that, let's say that the problem is that now we've got lower court decisions who are not following exactly the Cour de Cassation, the Supreme Court decision. So we will have, in few months, a new Uber case. But maybe it's because Uber changes its way of operating, which means that if we cannot find these signs of subordination, maybe it means that they are really independent, or maybe it's a resistance. But I will finish here because I already, yes, okay, and leave the floor to
Yolanda.
Bien, pues buenas tardes y muchas gracias por estar aquí esta tarde a esta hora que en España asimilamos con la hora de la siesta y que desde luego para mí pues no puede suponer un placer mayor que compartir panel y compartir mesa con tan queridos compañeros como los profesores Sylvain Lolon, Jeremias Prassel y presididos por nuestra querida Marie-Cécile Scan-Barniol. En mi caso, por supuesto, me voy a centrar en el papel de los tribunales nacionales españoles. Con todo, me parece que vamos a ver aquí a lo largo de esta tarde soluciones muy parecidas, muy comunes en los tres países que en este caso vamos a comentar. Tampoco podía ser de otra manera si tenemos en cuenta que el funcionamiento de las plataformas es un funcionamiento global. Son empresas que realmente operan de la misma manera en muchos países y por ese motivo también muchos hemos dado soluciones muy similares. En mi caso, a ver si soy capaz de hacer funcionar el PowerPoint. Ahora sí. Thank you. Me voy a centrar en la sentencia del Tribunal Supremo Español de 25 de septiembre de 2020. Esta sentencia tiene una relevancia absoluta en el derecho español y, por supuesto, en la jurisprudencia española, porque ha sido la sentencia que ha venido a unificar, como ha pasado pues, en tantos otros países, una doctrina judicial muy discordante, una doctrina judicial en la que, lógicamente, algunos tribunales optaban por reconocer la relación laboral, mientras que otros la denegaban. Y con esta sentencia, pues, el Tribunal Supremo ha venido a poner orden en esta cuestión y ha venido a confirmar la naturaleza laboral de un trabajador, de un repartidor de Globo. En este caso se trata de una sentencia que, lógicamente, tiene su origen en Globo, por lo tanto, es una sentencia centrada fundamentalmente en los repartidores de esta compañía, pero que, lógicamente, vamos a poder extrapolar a muchos otros repartidores de compañías similares, pues como pueden ser los repartidores de Deliveroo, a los que la propia sentencia también hace una pequeña mención, quizá como un guiño, para pues entender que es perfectamente extensible, repartidores de Uber Eats, que quizá nos deja la duda de qué va a pasar con otros trabajadores de plataformas que no son exactamente riders, que no son exactamente repartidores, pero que luego, pues como diré finalmente, la propia sentencia nos da unas pistas, nos da unos criterios suficientemente amplios como para que los podamos utilizar, no solamente para estos repartidores, sino, como decía el profesor Miranda esta mañana, para tratar de clarificar la relación laboral de esos trabajadores de la cara oculta de la luna, como pueden ser esos traductores, como pueden ser incluso abogados que trabajan para plataformas digitales y respecto de los que no se ha planteado pues tanto ruido como a lo mejor sí hay respecto de los repartidores. Aquí, como decía Sylvain, también el Tribunal Supremo Español ha hecho una función pedagógica muy importante, porque realmente ha cogido los criterios tradicionales que definían el contrato de trabajo, los ha explicado y los ha trasladado a estos trabajadores de plataformas. En el derecho español, el trabajador por cuenta ajena es aquel que trabaja de manera libre, de manera voluntaria, y lo que nos dice el Tribunal Supremo que es determinante. Trabaja con dependencia de la empresa y por cuenta ajena respecto de esa empresa. Y ahí el Tribunal Supremo se ha centrado precisamente para establecer la diferencia. Lo primero que nos dice, también lo sabíamos, el nombre no importa. No nos importa que, en este caso, Globo le celebre un contrato de trabajador autónomo económicamente independiente y le denomine de esa manera. Lo verdaderamente importante son las características de ese contrato, ¿no? Que se cumplan esas notas de ajenidad y de dependencia. Y también nos dice que esa concurrencia de dependencia y de ajenidad la tenemos que ver caso por caso. Por lo tanto, tendríamos que analizar cada relación para aplicar el supuesto o las notas de dependencia y de ajenidad y decidir si en ese caso estamos o no ante un trabajador por cuenta ajena. Y además nos dice otra cuestión muy importante en relación con lo que la propia Sylvain Lolon había comentado antes. Parece a veces un juego del gato y el ratón, y una vez que los tribunales van fijando unos criterios, las compañías modulan esos criterios para tratar de escapar. Lo que se nos dice en esta sentencia es que a lo mejor, aunque en determinados casos la dependencia no sea típica o la ajenidad no sea tan fuerte, hay que tener en cuenta todas las circunstancias alrededor de ese contrato de trabajo. Y solo viendo todas las circunstancias, solo con esa interpretación holística se puede clarificar si es un trabajador por cuenta ajena o no. Yo no voy a incidir excesivamente en esas características. El Tribunal Supremo lo que nos dice es que, dado que la definición de trabajador por cuenta ajena es tan abstracta, será necesario acudir a indicios, a aquellos elementos que nos permitan encajarlo en una u otra categoría. Y en este caso, pues, el Tribunal Supremo va desglosando las características de esta relación del repartidor de globo para tratar de ubicar esas características bien en el ámbito de la dependencia o bien en el ámbito de la ajenidad. Como nos explicaba antes Sylvain, pues se trata en este caso pues de una persona que realiza sus servicios bajo la coordinación y la organización de una determinada empresa, bajo unos criterios que no son propios, donde el Tribunal Supremo nos va a decir que hay una relativa flexibilidad y libertad, pero que es solo aparente, porque ese trabajador en realidad no tiene el derecho absoluto a decidir su horario, no tiene el derecho absoluto a decidir sus criterios, sino que eso lo hará dentro de los parámetros que le da la propia empresa. Las decisiones que adopte ese trabajador no son libres desde el momento en el que van a repercutir en el propio mantenimiento de su empleo. La franja horaria que él elija hará depender el volumen de pedidos a los que pueda hacer frente. Ese volumen de pedidos condicionará su retribución y, en último término, ese volumen de pedidos también condicionará su capacidad de continuar prestando servicios para la plataforma o bien de ser desconectado. Por lo tanto, la libertad no es tal, ¿no? La libertad es una libertad aparente. En este caso, también hace cierta relevancia o, bueno, pone de relieve el Tribunal Supremo que incluso uno de los elementos que había indicado Globo como representativos de la autonomía de ese trabajador era la falta de exclusividad. El trabajador podía prestar servicios para otras compañías y en este caso incluso también se pone de relieve que el propio trabajador es hasta un anuncio de la empresa. Todos nosotros, cuando vemos un rider con su mochila, automáticamente vemos la compañía. Por lo tanto, eso es también un indicio claro de la falta de ajenidad de ese trabajador o de su inserción dentro de la propia compañía. Y aquí, personalmente, yo también quisiera romper una lanza por este caso, por este trabajador, porque también hay que reconocer que en el sistema español es muy difícil que un trabajador que trabaja en un sistema de reparto de estas compañías realmente se anime a iniciar un pleito contra la compañía. Por el funcionamiento del sistema procesal español, la retribución que va a tener ese trabajador y la recompensa que va a obtener al final de un proceso tan largo como este va a ser mínima. En el caso de que se le reconozca su condición laboral, tendrá derecho a obtener una indemnización por despido, pero reconozcamos que no se trata de trabajadores que tienen una gran antigüedad en la empresa, con lo cual la indemnización que van a percibir es muy escasa y es mucho más habitual que estas compañías les ofrezcan en un acuerdo previo al juicio una indemnización mucho mayor de la que van a recibir en el propio juicio una vez que consigan ganarlo. Con lo cual, en este caso, esta sentencia es importante desde el punto de vista simbólico. Ha servido precisamente para para unificar la doctrina en este supuesto y, además, y sobre todo, para desencadenar también una reforma legal muy reciente que ha llevado a cabo el Real Decreto Ley de 9/2021, de 11 de mayo. Este Real Decreto Ley recoge expresamente la sentencia del Tribunal Supremo. De hecho, está muy ceñido, muy pegado a esa sentencia. Comenta el propio Real Decreto la importancia del principio de realidad, de que no importa cómo se llame el contrato, sino qué características tiene. Y además también insiste esta reforma legal en la necesidad de entender que ni la dependencia ni la ajenidad son conceptos fijos, sino todo lo contrario. Se trata de conceptos flexibles. En la línea que antes afirmaba Sylvain Lolong, tenemos las herramientas. Simplemente lo que necesitamos es saber aplicarlas de una manera adecuada a cada uno de los distintos panoramas que nos van a ir surgiendo y adaptar la dependencia y adaptar la ajenidad a los requisitos de cada momento y de cada época histórica. Este no es un problema nuevo. La propia sentencia del Tribunal Supremo reconoce que también se ha tenido que pronunciar sobre el carácter laboral o no de otros trabajadores en épocas anteriores, como fueron los mensajeros en el año 1986, como fueron después los repartidores que en aquel momento utilizaban una motocicleta propia en el año 88 y como fue hace menos tiempo, en el 2017, los traductores que también utilizaban plataformas. No es una cuestión nueva, simplemente ahora nos estamos enfrentando a una empresa que funciona de otra manera. Y en este caso, la reforma legal, sobre todo, insiste en dos elementos. Se modifica el artículo 1 del Estatuto de los Trabajadores simplemente para reconocer expresamente la condición laboral de los repartidores al servicio de plataformas. Ya no va a haber duda alguna. Se trata de trabajadores por cuenta ajena, con lo cual, en este caso, ya no es necesario recurrir a la jurisprudencia. Y lo más importante, a mi modo de ver, y sobre todo en relación con lo que nos interesa en este proyecto, que van a ser sus derechos colectivos, los derechos colectivos de estos trabajadores. Se modifica también el derecho a la información de los representantes legales, precisamente para que estos, en concreto en el derecho español, el comité de empresa, los delegados de personal, tengan derecho a conocer determinados elementos. La empresa, entendemos que es un artículo dirigido fundamentalmente a la empresa, que tiene que proporcionar a estos representantes de los trabajadores determinados datos acerca del funcionamiento del algoritmo, y nos dice la modificación que puedan incidir en las condiciones del trabajo y del acceso y mantenimiento del empleo, incluida la elaboración de perfiles de estos trabajadores. Esto prácticamente supone la obligación de estas empresas de informar a los representantes legales precisamente de los elementos determinantes de la condición laboral de estas personas. Yo me he permitido hacer aquí un pequeño esquema en el sentido siguiente. Si hay que informar a los representantes de los trabajadores de aquellos elementos de funcionamiento de la plataforma que incidan en sus condiciones de trabajo, en el acceso al empleo y en el mantenimiento del empleo, estos son precisamente los datos utilizados por el Tribunal Supremo para determinar la laboralidad de estos trabajadores. Por ejemplo, el sistema de asignación de pedidos que utiliza la plataforma, que utiliza en este caso Globo. Ese sistema de asignación de pedidos, como decía antes, incide en la elección de la franja horaria del trabajador. incide en la libertad precisamente del aceptar o rechazar pedidos en función pues, de la franja horaria que hubiera elegido. E incide también en la elección de la ruta del trabajador. Son tres elementos que el propio Tribunal Supremo ha tenido en cuenta para encadenarlos o, bueno, para incluirlos dentro de la capacidad de control de la empresa, para determinar que Glovo controla realmente el trabajo de esa persona y no es una persona que lo desarrolle con total libertad. En segundo lugar, el sistema de puntuación otorgado a los repartidores. ¿Cómo van a determinar las plataformas la puntuación de un rider cuando ese sistema de puntuación, como decía antes, depende en unos casos de la valoración del cliente? El cliente, una vez que se le entrega el pedido, puntúa al repartidor y esa puntuación va a determinar también el mantenimiento del empleo del propio trabajador. Por tanto, de acuerdo con esas tres preguntas que aparecen ahí, que son realmente los tres elementos que determina el decreto ley como necesarios para obligar a la empresa a informar a los trabajadores, ¿el sistema de puntuación del repartidor se va a basar el algoritmo en ese elemento? Por supuesto que sí. ¿Afecta a la toma de decisiones tanto de la empresa como del trabajador? Afecta. Y además, ¿puede incidir en el acceso al empleo o en la salida del empleo de ese trabajador? Sí, por lo tanto, es necesario que esa información se produzca. El sistema de retribución del trabajador, que es el tercer elemento empleado por el Tribunal Supremo. Yo ya lo dejo al criterio de nuestros oyentes, pues la respuesta a esas tres preguntas. Si de verdad podemos entender que el algoritmo determina el sistema de retribución del trabajador o no, si una vez determinado ese sistema de retribución va a afectar a la toma de decisiones por parte del empresario respecto de esos repartidores y si puede afectar o no afectar al mantenimiento del empleo de ese repartidor. Pero bueno, en cualquier caso parece obvio que un empresario tiene que informar a los representantes legales de cuál es el sistema de remuneración empleado. Estos son simplemente tres elementos utilizados por la sentencia para determinar el carácter laboral, pero nos abre la puerta a mucho más, porque la información que tiene que dar el empresario a esos representantes de los trabajadores no va a afectar solo a esto, va a afectar también, por ejemplo, en derecho español, al mantenimiento de la igualdad entre trabajadores y trabajadoras en materia salarial. Va a afectar a las condiciones de seguridad y salud de esos trabajadores. Por lo tanto, nos abre una gran puerta al papel que esos representantes van a tener a partir de ahora en el conocimiento de esas condiciones de trabajo. Nos aclara, en todo caso, el Real Decreto que siempre respetando el secreto industrial y comercial. Habrá que mantener ese cuidado, porque se podrá informar ciertamente hasta un punto, pero tiene que ser una información útil. Desde luego, la empresa no se puede limitar a mostrar un algoritmo que los representantes de los trabajadores no van a poder descifrar y no van a poder entender ni utilizar para sus funciones. Y que al mismo tiempo, pues eso nos abre la puerta a múltiples perspectivas y a la entrada, por fin, de la negociación colectiva en esta economía de plataformas. Yo termino aquí por cuestión de tiempo. Muchísimas gracias y también cedo la palabra al profesor Jeremiah Presley.
Muchas gracias.
Thank you very much indeed for these two really interesting presentations. It's going to be a hard act to follow. And also, much like Marie-Cécile said at the outset, a very major thank you to Jose Maria for organising us today and for bringing all of us here and to the entire organisational team. Could I also have my slides, please? I've prepared a slide deck. Thank you very much indeed. So in thinking about the UK experience with the Uber litigation and following, I think, on quite neatly from the two presentations we've heard, there's really three things I want to do today. First, I want to look at the actual decision of the Supreme Court itself and also just set it against the context of the litigation history. So I think one thing in which the UK experience might be different from what we've seen both in the Spanish and the French case is the sheer consistency of decisions when it comes to Uber, at least in particular. Not all gig economy companies, there have been exceptions, for example in Deliveroo, but certainly in Uber we've seen 4 instances of judges coming to precisely the same agreement. And then I'll talk briefly about the substance of the decision, both the question of worker status, but also, and that's something that might be interesting for us to talk about in the discussion afterwards, also the issue of working time. Because the other big question, of course, the Supreme Court had to face is, if Uber drivers are workers, then when are they working? Whenever the app is switched on, or only when they've actually got a passenger in the car? And then against that, I want to take a step back and think both about the doctrinal and the more practical and policy implications of the decision. So when it comes to the doctrinal implications, the first thing I want to do is, in a sense, highlight how English law is finally catching up with the principle of the primacy of facts, which we've heard so strongly enunciated in the other decisions. And I think Uber sort of shows us catching up here with continental jurisdictions. I'll also highlight what is starting to become a very clear shift, I think, in English law from an emphasis on contractual analyses of the employment relationship to an emphasis on the statutory interpretation. And actually, I think in that sense, the Uber judgment could well come to be seen as important far beyond the gig economy when it comes to how we understand and regulate employment relationships. And then I'll just ask the third question, which is one that's actually been left open by the Supreme Court, which is, technically speaking, the litigation was about worker status, Section 233B of the Employment Rights Act. One interesting question is, will this new approach that the Supreme Court has set out apply also to employees, or is it an approach that's limited specifically to this binary category we've got? And then finally, and I think this is where the discussion will tie in very nicely also with the overarching theme of the COGENS project, is I will discuss some of the implications, some of the aftermath of the judgment. Because we've seen a complete change in response within weeks. Uber's initial response saying, tough luck, none of this applies to us, to very quickly saying, actually, we are going to agree, and then only a very few weeks ago, actually deciding to sign a collective bargaining agreement with the GMB union. So against that background, let's start by thinking about just a very short history, I guess, of the actual litigation. So the Uber litigation in the United Kingdom started as long ago as 2016. So really what you're looking at here is to settle what is technically actually just a preliminary question as to the status of these workers, taken over 5 years. And you had a very strong judgment of the Employment Tribunal. Some of you will remember the language, the witness, Uber's general manager being referred to as Queen Gertrude, Uber being criticised for using armies of lawyers and twisted fictions. I mean, a very punchy judgment by English standards. Upheld in the Employment Appeal Tribunal in 2017, that again upheld by the Court of Appeal, though with one judge dissenting, Lord Justice Nicholas Underhill dissenting in the Court of Appeal, finding that actually these were commercial contracts rather than contracts of employment. And then nearly a year after the Supreme Court heard the case in July 2020, finally we get the decision in February of this year. It was a unanimous decision of 6 judges given by Lord Leggett, and in the core of the judgment, Lord Leggett upholds 5 key features of the Uber business model, which he suggests, and the other justices agree, explains that this has to be in a relationship of employment. Uber first, he explains, sets the fares, decides how much workers actually earn. Uber imposes all the contractual terms, no negotiation or variation of them possible at all. He also highlights various ways in which Uber constrains workers' choices, right? This goes back to what we've already talked about, this power of sanctioning, I guess, will be the closest equivalent. For example, through these penalties that Uber, at least historically, has had in place to make sure workers actually accept rides. Various elements of algorithmic control highlighted, in particular the rating system, much like we saw in the Spanish context. Also, interestingly, an emphasis that Uber does everything it possibly can to restrict direct communications between passengers and workers. So there's this one particular feature where Uber actually creates a fake invoice, which technically the driver sends to the client, but that invoice misses everything but the first name of the client, precisely to make sure there can't be any sort of genuine entrepreneurship. And on that basis, this combination of the tight control and the lack of entrepreneurial opportunities, the Supreme Court found that Uber drivers were workers. And in a sense that, as you know, I and others have argued for a long time, that was the fairly straightforward point. Given the extreme degree of control Uber exercises, it'd be very hard to see any other decision. What I find, in a sense, the much more interesting decision was as to the question of when are Uber drivers working? But the company's sort of subsidiary argument was to say, well, even if they are workers, we're only going to pay for working time when they're actually with a passenger in the back of the car. Whereas the drivers said, well, no, there's a sanction every time we don't accept the ride. So therefore, all time we are logged into the app should count as working time. And again, it was on the basis of these algorithmic sanctions that can be applied to punish workers, for example, through the short terminations for up to 10 minutes that Sylvain has already mentioned, that the Supreme Court found for the Uber drivers also on the secondary question whether working time is involved here. So let's think briefly about the doctrinal implications. Why is this judgment a big deal beyond simply the gig economy, beyond simply Uber drivers? And there's 3 doctrinal points I really want to highlight. First, this very clear, very strong endorsement by the Supreme Court of 𝐂𝐻𝐻. So Uber, in its arguments, for example, paragraph 44 of the decision, was very clear that there were contractual agreements in place, the workers had provided that it was in fact Uber providing services to the workers rather than the other way around, and that therefore they were clear, unambiguous terms, and as long as the terms were clear and ambiguous, the judges weren't allowed to look beyond to the facts and had to stick to the contract. And indeed, that is what had convinced Lord Justice Underhill in the Court of Appeal to say, yes, Uber is just like Booking.com or any other sort of pure intermediary. There's no control here. It's a commercial contract. Now, the Supreme Court strongly disagreed with that. The Supreme Court went back to an earlier decision in 2011 in the case of 𝐂𝐻𝐻 and Belcher, where the court had said, well, given the inequality of bargaining power between the parties here, we have to look at the reality of the relationship. This is not a genuine contractual agreement. This is imposed one-sided by a single party. And I think that's a huge doctrinal shift for English law, because we're moving away very clearly now from a world in which the contract of employment is treated like just any other bilateral contract between parties, to a world in which the senior courts actually recognize that there's some very specific features to employment contracts, and that therefore actually our whole structure of employment law might have to be rethought. And so in paragraph 63, you see precisely this quote from Lord Justice Aikens, thinking about the relative bargaining power of the parties, and then say that actually to understand what the true agreement between the parties was, you have to look beyond the contract. So the next big question is, if we're going to ditch contract law, what should we do instead? And where are we going to get those regulatory norms from instead? And here, Lord Leggett then shifts on to the purpose of statute and purposive interpretation. So the reason Lord Leggett explains why we have to move beyond contractual interpretation is that the claimants here are not actually trying to assert contractual rights. The claimants are trying to assert and enforce rights given to them by Parliament, by the legislator, rather than something they set up in a bilateral contract. And therefore, and this is the really important twist at paragraph 71 of the judgment, therefore we have to focus on the purpose of the statute. And the purpose of the statute, in the context of the Employment Rights Act of 1996, is identified by Lord Leggett as the protection of vulnerable workers. Indeed, he goes as far as at paragraph 75 to say that situations like those of gig economy workers, and I quote, cannot safely be left to contractual regulation. Again, against the background of the English common law, that's a very big, very powerful statement indeed. And in a paragraph, which I'm sure we will be using in exam questions for many years to come, at paragraph 77 of the decision, Lord Leggett then also makes it very clear that the reason why we need this new approach is that otherwise apps employers would end up with the choice of whether the law applies to them or not. And I quote, he says, anything else would accord Uber the power to determine for itself whether or not the legislation designed to protect workers will apply to its drivers. So it's really interesting. Of course, we don't have the distinction between a constitutional jurisdiction and a civil jurisdiction as such, but there's some very strong constitutional overtones in this judgment as well. This is not just a labour law judgment. There's some very strong constitutional sentencing in there saying, actually, this is about what Parliament intends, and this is about the rule of law and applying and enforcing those norms. Now, the one question that was left open and that will now be to be litigated again is, to what extent will this approach, which was developed in the concept of the worker, our intermediate category, also apply to the employee? Now, again, our definition of the contract employment, much like in French law, there's no statutory definition. It's left to the courts. But the contract for workers is actually specified in Section 233b. So on the one hand, you could argue, actually, the approach in Uber should be limited very much to the third intermediate category. On the other hand, I think given this broader constitutional thrust of the judgment, I think what we will see is that actually it will be attached to all categories of status, not just to this intermediate category. Though I'm sure there will be people running precisely that counter-argument in litigation to come, and I don't think we've seen the end of this story. Now, just very quickly to conclude, I just want to talk a little bit about the follow-up as well, because something very interesting and quite curious happened. And again, it would be interesting to compare the follow-up as well in what happened in France and what happened subsequently in Spain. So immediately after the judgment, Uber gave pretty much the standard press release to expect. It said, sure, we'll respect the court's decision, but it doesn't matter. The judgment only applies to the 5 or 10 or 15 workers who brought this case. The 70,000 other ones are working on a completely different business model. We have, of course, changed our app a little bit, and therefore we no longer exercise that control. Now, Sylvain, this actually goes back to a point you raised about this new French case coming. I find it potentially quite risky on Uber's part to admit that they constantly change the app, because actually you could argue that this constant changing of conditions is in and of itself a clear indicator of just how much control you exercise. If I can constantly every other day tell you, oh, today we're playing a different game, today we're playing a different game, I just think that's an indication of control in and of itself, even if you change the particular levers of control. But there was also a problem for scholarly and policy discussions at this point, because the real question was, if Uber can get away with this, how do we enforce employment law? Right? Will we have to relitigate? Remember, this took over 5 years to actually get to this judgment and hundreds of thousands of pounds in lawyers' costs. Are we in a position where a company can essentially, even if the Supreme Court says you have to comply with the law, just say, yeah, we don't agree with that, and let's just go litigate again? And that was a really huge issue, and I think one that, in practice, is still very much one for UK labour market regulation to grapple with. Uber, on the other hand, just after a month later, completely changed its game. So in an op-ed written in the London Evening newspaper, the CEO of Uber said, we're going to recognise worker status and we're going to accord basic rights to workers. In particular, as he then mentioned, we're going to pay the minimum wages and we're going to accord holiday pay and pension insurance. The interesting twist in this, we're going to follow the law, was that he also made it very clear that they disagreed with the Supreme Court's definition of working time, and that Uber was only going to accept that for the time actually in the car with the passenger. So really interesting sort of, big public announcement, we're complying with the law, and then actually when you look at it in the detail, not quite what was suggested. What was also completely quiet in that judgment, and indeed afterwards in discussions with various Uber policy executives, was whether the other important rights of worker status would be accepted, and including, of course, for our purposes, the right to bargain collectively, to be recognised by a trade union. And there was long silence on this point for nearly another month, until in May in 2021, so only a very few weeks ago, in a big announcement, the GMB, one of the major UK trade unions for the transport sector, announced that Uber was in the process of recognising them as the responsible trade union for their workers. And indeed, there was going to be collective bargaining to cover over 70,000 drivers in the UK. Now, again, that's great news in principle, but I think the devil will be in the detail, and actually it'll be very interesting to see the nature of that collective bargaining agreement and to see whether that collective bargaining agreement will genuinely enhance workers' rights, or whether in turn it might be used as a way of picking and choosing which bits of the law to comply with and with not. And I suppose, going back to the broader constitutional dimension of Lord Leggett's decision, it's really important that we should welcome this agreement if it's the former, if it ensures genuine compliance with the law. We have to be much more careful if we see the pattern that's been followed by Uber and other apps in other jurisdictions, where actually certain forms of collective bargaining, certain forms of specialized regulation are in fact used to create a specialized regime that ultimately protects lower provisions than the law does. That's it for me. I'm really looking forward to discussions. Thank you very much.
Thank you very much. Yes, I'm a little like Franz. I would like to. I think that. Oh, thank you very much. It's so much warmer. It's on live. So now we have time for questions, but I don't know how the questions are coming from all around the world.
Can I start with a quick question for Yolanda? So
yes, because I think it could be very interesting to have discussions between the different countries and the role of the judges in front of politicians and legal systems. Because it seems that the influence, it's very different from a country to another. In France, it's clear that political want to keep on the independent statute. But in Spain, and perhaps in UK, but it's more difficult to say for me, the temptations of presumption of worker, it's more in the political program. It seems so, I don't know. But I leave you speaking one with the other. We want to, I don't know.
Bueno, empiezo yo diciendo simplemente que en efecto, en España, inicialmente yo creo que fueron un cierto paralelismo entre el papel de los jueces y el papel legal. Sí es verdad que inicialmente los tribunales fueron más rápido porque llegaron los casos a los juzgados mucho antes de que el gobierno pudiese dictar una norma que aclarase esta situación. Pero creo que desde el primer momento sí hubo una intención legal o una intención política de reconocer legalmente el papel de estos repartidores como trabajadores por cuenta ajena. Lo que sí se buscó fue un consenso. No se quiso imponer esta medida, sino que se quiso, digamos, publicar con ese respaldo tanto de las asociaciones de empresarios como de la parte trabajadora. Judicialmente, la discusión la encontramos más en los tribunales inferiores que en los superiores, así como dentro de nuestros tribunales inferiores, que son los juzgados de lo social, podíamos encontrar, no quiero decir que un igual número de sentencias a favor que en contra, pero bueno, sí muy similar. Cuando esos pleitos llegaban a la instancia superior, al tribunal superior, la gran mayoría de esos tribunales regionales, de los tribunales superiores de justicia en España, uno por cada comunidad autónoma, por cada región, la gran mayoría reconocían el carácter laboral de esa relación y prácticamente dos reconocieron su condición de trabajadores autónomos. Y una de esas sentencias fue precisamente la que dio lugar a este recurso que terminó con la sentencia del Tribunal Supremo. Pero yo me atrevería a decir que la intención, tanto política como judicial, desde el primer momento fue similar. Fue, como decía Jeremías, dar una protección al trabajador débil. Desde el primer momento hubo ese deseo de proteger pues, a quien se entendía que estaba contratado en fraude y con unas condiciones que no eran las que les correspondía. También he de decir que no fue pacíficamente recibida por todos los riders este reconocimiento como trabajadores por cuenta ajena, sino que buena parte de esos trabajadores estaban cómodos con la condición de trabajadores autónomos económicamente dependientes porque bueno, entendían que económicamente les favorecía más. Muchos de ellos pues, son trabajadores extranjeros que tampoco tienen interés en tener una carrera de cotización en España, una pensión de jubilación, sino que piensan trabajar aquí un tiempo y a lo mejor volver a su país, con lo cual se sentían más cómodos en la otra figura. Pero bueno, esa es un poco la situación aquí. Jeremias, do you want to?
I think just very briefly, I think it is interesting that the statute that was being used here was the Employment Rights Act of 1996. So actually a statute that was 25 years old at the time of the decision. But we've generally had this trend in Supreme Court employment law decisions. I'm thinking also of the Unison decision, for example, 2 years ago, of the Supreme Court emphasizing that once Parliament has granted rights, it's not for either the government or private sector employers to actually carve that out. But again, it's not consistent. So one interesting decision to juxtapose is about 3 or 4 weeks later, the Supreme Court handed down a case called MENCAP, where the decision was as to working time for carers who work in people's homes. And it was really interesting, after the Uber decision, people thought, well, it's going to be likely that actually carers sleeping in someone's home are also going to be held to be working in working time. And the Supreme Court decided the opposite. And the Supreme Court actually decided that it didn't count as working time, even though you had to be in the client's home and sleep there. And that's interesting. So, you know, one school of criticism suggested there was a significant gender imbalance to this, that you had, you know, the male drivers found to be in working time, the female carers found not to be working. So I think there are still lots of inconsistencies as well in the jurisprudence, but the overarching thrust is this sort of constitutionalization of at least the enforcement of employment rights.
Do you want to say something on this question, or perhaps if you want to take the question of
yes, maybe
Oriana?
I will answer to the question and also ask or comment on the two presentations. So the question is if I will say that the Cour de Cassation in the Uber case has come back to the pre-Société Générale case law when a particular importance was given to business integration. Well, I will say that it's not written back before the Société Générale case, but it's true that in Uber, the element of integration in a service was important because it was the one of the elements which was taken into account to conclude that there was a contract of employment. So it's not the only element, but it was one of the elements. And it's true that the fact that the organization of work is completely under the control of the platform and that the drivers do not have anything to do in this organization was one of the elements with other that makes the court conclude of the contract of the employment. But what was also important in the Uber case, and I didn't mention it, is that at that moment, the Uber drivers has the freedom to connect whenever they want to the app with no sanction on the. So it was so. The Cour de Cassation recognized the contract of employment, but just for the period of connections and not for, let's say, a general period of employment. But the court did not have to answer on the question on working time, because the only question was the existence of contract of employment to recognize the competence of the labor court. And after, maybe the question will come to working time. But for the moment, it was just a question of competence, so just a question of the existence of a contract of employment. And the other thing I will also add is that maybe like in Britain, or at least we can do a parallel, what is happening after the decision? Because you can say, so we had this decision, it's a contract of employment. So you can imagine a reaction of the state fighting against these contracts. No. You can imagine a huge amount of cases of people going to court. You've got some, but not such a huge amount. I think it's also because you go to court when you have a problem, and not just because you think that maybe you have a contract of employment. And you can have, so in France, the reaction is that you've got some cases, but not, let's say, a stream of cases and so on. And also you've got a legislative answer. So we had a new decree in April, May of this year. A new regulation is expected. And what is interesting is that you still have this legislator in France. Maybe it will change sometime, but for the moment, they really want the platform workers to be independent. But they cannot touch, I will say, the definition. So they just regulate the independent workers, platform workers, which means that, of course, the judges can reclassify them, but they regulate the independent workers. And what is interesting is that for the moment, what are they doing is that they try to organize social dialogue for these independent workers, not to have a legislative regulation, but to have a collective regulation, which is totally, of course, the project, the aim of the project. So it's not through individual legislation. We don't know if it will work, but for the moment, the government tries to organize social dialogue for these independent workers.
And if I may just quickly respond to that, I think in principle that's really good and really promising, right? Because actually when it comes to the enforcement problem, when you think about the three avenues of enforcement, state, individual litigation or collective enforcement, that could be really useful. I think what we then have to be careful about is that it doesn't become pick and choose enforcement. Yeah. And it doesn't become sort of saying, you know, yes, you can have these rights, but I'm not going to give you these other rights. And I think that's precisely the point that sort of Lord Leggett made, is that if we live in a system under the rule of law, you don't get to say, oh, yes, I'm going to kindly give you those rights, but I'm not going to give you those other rights, right? That's the very antithesis of legal regulation of the labour market.
You have a question, Jeremias, from Lucan. I don't know if you can read it. To Jeremias, how much would you see your argument about Uber changing its app every second day from a comparative perspective? How much employers' discretion may be sacrificed here?
Thank you, Luca, for a really interesting question. I think it goes back to, and it's actually another interesting point, is that the Court of Justice was cited by the UK Supreme Court. And actually, very much like it sounds like the French decision, the UK Supreme Court, without even mentioning Brexit, cited the recent decision by the Court of Justice in AFMB, which was the Court of Justice decision about the exercise of employer functions. And so to me, actually changing the app, setting out how, what I would call in my analysis of employer functions, managing the enterprise internal market, yes, the employer has that discretion, absolutely, and through algorithmic management can exercise it to a very high degree. But that also then has consequences insofar as legal responsibility is then ascribed to that.
Do you have another question? I don't know if
How would I explain the adoption of the EU court's principle in the Uber case? I mean, I think in one sense, the Uber case was a very easy one in which to apply and sort of, you know, strengthen the principle of facts, because particularly if you go back and read the analysis in the employment tribunal of the contract was written in such an extreme way, so far removed from the reality of the situation, that actually it was very easy for a judge to say, on the facts, not a single element in this contract has anything to do with what's going on. I mean, the idea that the app would somehow be an agent for the drivers, introducing them to their passengers, it's the joke I used to make is, what if every Viennese cafe just reinvents itself as a cake and coffee platform and then, you know, provides intermediation services to waiters? It just couldn't be further from the reality of the situation. So on the facts, given the extreme control and the very extreme wording on the contract, it was actually, I think, quite an easy case on the facts for the court to make that statement and development.
Thank you. And the other question is for Yolanda. Can you read it, or do you want I read it? How would explain the presumption in the Spanish rule? Iuris tantum or iuris de jure?
La presunción en España es iuris tantum. Es decir, se presume, lógicamente, que existe relación laboral entre todo aquel que recibe órdenes e instrucciones para su cumplimiento a cambio de un salario. Quien tiene que destruir esa presunción, lógicamente, es el empresario que afirma la no existencia del contrato de trabajo a pesar de concurrir esas circunstancias. ¿Qué sucede? Que el hecho de que ahora expresamente en la legislación ya esté reconocida que la relación entre los riders y las compañías, las plataformas, se entiende como trabajo por cuenta ajena, aunque continúa siendo presunción iuris tantum, es como un refuerzo adicional, ya es un extra a favor de ese reconocimiento. Entiendo yo que ya, como comentaban antes mis compañeros, ya no queda en el papel de los tribunales la decisión, sino que ahora ya ese mandato ya es un mandato legal.
Pero eso es muy interesante porque es exactamente lo que no quiere el legislador, el gobierno francés ahora, que haya una presunción.
Claro, en este caso es, insisto, es una presunción que admite prueba en contrario, pero es una presunción en ese sentido, sí, sin duda.
Y bueno, otra cosa, in English, what will be the impact of the 𝐤𝐸L case on national case law? That is interesting because I wanted to say that the 𝐤𝐸L case came just after the French case, but just before this, the Spanish one, and before the Brittany one. And in the Spanish one, the judges emphasizes that there is like an answer to the 𝐤𝐸L case. In the 𝐤𝐸L case, you say that. So in the ruling, the judges take it in care. It's very interesting. So I like to prep the floor. Otra que es en español, ¿cómo interfiere el diseño institucional de los sistemas de justicia en el tratamiento del asunto? ¿Ve alguna diferencia cuando se trata de un tribunal especializado o un tribunal común? Es una cuestión de procedura española, me parece.
Una cuestión muy procesal. En el sistema español, pues digamos que hemos tenido la particularidad de que tanto los litigios entre trabajadores por cuenta ajena como entre trabajadores autónomos económicamente dependientes son materia ambos de la jurisdicción social. Y la jurisdicción social, en ese sentido, como jurisdicción especializada, siempre está orientada a la defensa del trabajador como parte débil de la relación laboral. Sería muy distinto, yo me atrevo a decir, y es una opinión puramente personal, que quizás sería muy distinto si estos pleitos hubiesen ido o se hubiesen correspondido a la jurisdicción civil, que por supuesto se basa sobre la igualdad de las partes contratantes. Sería completamente diferente. Por lo tanto, aquí yo creo que la importancia de una jurisdicción especializada lo ha sido todo, absolutamente todo.
Exactamente lo mismo en Francia. Como lo decía Sylvain, la primera pregunta estaba la competencia del tribunal.
y en otros casos de otras plataformas es el Tribunal de Comercio que está competente y siempre dice son independientes y la plataforma es un intermedio. Así que según el juez, sí, bueno, Jeremias, according to the Supreme Court decision, if the driver is online or on more than one platform at the same time, will that time count as working time?
Thank you. I think that question raises a really important red herring, both legally and economically, when it comes to the analysis of the gig economy business model. The short answer is no, that can't happen. Because precisely as the Supreme Court says, it's the sanctioning mechanism that stops a worker from doing that. So yes, in principle, I could just turn on the Uber app and then go to sleep and have it lie there. But what Uber will do is, as they start sending me ride requests and I don't respond within a certain time frame, I will be deactivated. And I think that's really important, and in a sense was the crux of the working time finding, that there is punishment for non-acceptance. And as long as that sanction regime exists, the working time should matter. Now, I was saying earlier that Uber changing its business model, to me, doesn't change the analysis of control. And that's the point that Luca also raised. I think when it comes to the analysis of working time, the absence of sanctions does change it. So if the Uber business model is genuinely that I can log on the app, I can sit all day online on it, and there's no punishment at all for me to accept the ride, no downgrading of my ratings, no other sanctions, then I would agree with the characterization of working time only when a passenger is actually in the car. Now, here comes the important economic footnote to this, which is as follows. Counterintuitively, but the highest value a driver actually has to the platform is not when they've got a passenger in the car, but actually when they're empty and circling. It's the option value. So it's counterintuitive because, of course, technically speaking, the driver earns money for the platform once she's got somebody in her car. But the actual value to the network effect and to the overall business proposition is that you want to have as many cars circulating as possible. So even from a sort of law and economic analysis, I think you can say paying drivers for providing that option value, as it were, is something that the law should recognize.
Thank you very much. So it's time to end this session. Thank you very much, because I think it was really interesting, and all the questions show that the audience was very interested by your presentations. So thank you. And now I think that we have a pause. Oh, yes. And we will meet at 30, no? 4:30. So after the pause, we will meet you. Thank you.
Thank you.
Thank you.